Welcome to Property Power Talks, the exclusive podcast for NB Property Law. I'm your host, Kaylee Swift, and each episode will dive into cutting-edge insights on property law, probate, estate planning strategies, and seamless estate administration. Whether you're a property investor, homeowner, industry professional, planning your estate, or wanting to understand how estate administrations work, then our expert discussions will empower you with the knowledge you need to navigate the complexities of property and estate planning law with confidence. Let's unlock the power of property and estate planning law together. Good morning, everyone. So my name's Kaylee Swift. I'm the director here at NB Property Law. So for those of you that don't know who we are and what we're all about, so NB Property Law is obviously providing estate planning legal services to our clients, and as the name suggests as well, also property law services. So we do everything from drafting simple estate planning matters from wills, powers of attorneys, through to complex family provision applications when people are contesting wills, applying for probate, drafting up power of attorney document, and then on the property side of things, everything from residential mum and dad conveyancing through to commercial purchase and sales, along with retail commercial leases, and also things in terms of body corporate, so disputes or creating community management statements, etc. So today, obviously, you're hear all about your Mastering Legal Preparedness in terms of what wills are all about, what is a power of attorney, when it's important to have one, how they operate, and also going through family provision applications and demystifying some of the areas that you may be unaware of or how it all works in the legal space. And so essentially our agenda for today, so as I mentioned, we'll cover everything from what actually is a will, who can have a will prepared in Queensland. We'll go through things such as like what is the vesting age that we have for beneficiaries in wills, what are guardianship provisions and when are they needed, how power of attorneys operate and why you should have one. So as I said, my name's Kaylee. I'm the director here at NB Property Law. We like to think that we offer a personalised, proactive advice to clients to help them minimise their risk and take the stress out of your next property transaction or estate planning matter. We're more than just a team of legal experts. We're dedicated problem solvers, committed to creating personalised solutions to guide you forward. As I mentioned, we do everything from residential, commercial, property law, and we're also here to help provide you clarity and guidance that you need. So NB Property Law is part of our wider group, which is called the NB Law Group, and we have 4 divisions. So as I mentioned, this is NB Property Law. We also have NB Migration Law, NB Employment Law, and NB Commercial Law divisions within the NB Law Group. So what actually is a will? So a will is a legal document which states what you wish to happen with your assets and your estate once you pass away. So there's no point, obviously, building up all this wealth if the estate and everything you've worked so hard for is actually not going to who you would ultimately wish for it to go to. Within your will, you can nominate who's going to receive the benefit of your estate, and these are known as the beneficiaries. You can have multiple beneficiaries appointed. We often, when we're drafting your will for you, will recommend that you have different layers for every role that we fulfill. So with a beneficiary, often in a quite a simple, mum, dad with a couple of children, everything generally will go to the husband or the wife, and then as a next layer to the children. Third layer may be grandchildren, and sometimes they'll split it out as well. You might have 50-50 to a sister and a brother or something like that, but it's up to you as to how you want to divide the estate up. But we want to have obviously different layers in case the unforbidden would happen and everyone was to pass away in a family car accident or something like that. We always need to have those different layers. So your will should also outline who you wish to actually be the executor of your estate. So the executor is also known as the trustee or the administrator. As that name suggests, they're essentially in charge of actually administering the estate. So they do everything from, they'll be obtaining a copy of the death certificate, they'll be in contact with your lawyer, with your accountant, make sure everything's divided up to the beneficiaries. We'll assist in the process of applying for probate, but they'll essentially be the ones signing off on everything to get everything basically finalised before the actual estate is administered and distributed out to the beneficiaries that are listed. So who can actually have a will prepared in Queensland? So everything in Queensland in terms of estate planning is guided by our Succession Act. They're different for each state. So when having a will in Queensland, so the court states that you may in its direction grant probate of a will or letters of administration of the estate of a deceased person, notwithstanding that the deceased person left no estate in Queensland or elsewhere, or the person to whom the grant is made is not resident or domiciled in Queensland. So you don't need to live in Queensland or have assets in Queensland to have an Australian will. The executor also doesn't need to be based in Queensland to have the court approve the will, but they should at the very least be located in Australia, because the courts have refused to allow executorship where the proposed executor was overseas and not interested in coming to Australia to administer the estate. So often clients will, want to put down an executor as, a son that might live overseas, and that's quite okay. But when it comes to the actual administration of that estate, it is generally important that that person is able to be present and sign documents that we need to actually have the court administer the grant of probate so that the estate can be administered properly. We always say that, if you are getting a Queensland will drafted, that it's generally because you've got some type of asset here. Generally a client's got, a property here or they're living here, which is why they'd get their will drafted in Queensland, because there are different succession laws for each state. If clients are predominantly living in another state and all their property is down there, they'd be recommended that they have a solicitor or lawyer in that state to draft their will. So what is the actual role of the executor in the will? So this person is an individual, can be an organisation, and they're responsible for carrying out your wishes once you pass. They attend to payment of all your debts and taxes before dividing up your estate and distributing it to the beneficiaries that are listed. So often when a client doesn't know or doesn't have anyone they trust, no family left, they may appoint us as a solicitor to be that executor, but more times, they've got someone that they know and trust quite well. So whether it be their spouse, and then again, they'll have a second layer. So if it's not the spouse, it may be a child that they're putting into that role to administer the estate. That will often be done, as I mentioned, in conjunction with the legal team to assist them as to how you go about applying for probate and contacting all the asset holders and getting the money, essentially it'll come into our trust account or an account that's set up for the estate to deal with the distribution before it goes out to the beneficiaries. So when we distribute money to beneficiaries, sometimes there are children involved or people under a certain age. Now, we often will include a vesting age for the beneficiaries. So essentially what a vesting age is the age at which the beneficiary can actually inherit the money that they've been left behind. So with our wills, we generally put that as 25 years old. We think by this age they're generally mature and able to manage the wealth they're receiving. So, they've finished potentially any secondary, tertiary studies, and they've, been able to experience life, and they're not just going to essentially go and blow the money, before 18, before they actually know what to do with money and how to properly manage it. But it's up to clients to dictate and provide instructions on what they want as their vesting age. That is what we would recommend. Sometimes clients say, they trust their children, they know their children, they're quite switched on. They might put it as 18, they might put it as 21. It is the client's right to provide that instructions, but 25 is the recommended age that we would put in otherwise. So in terms of children, the other provision, if you do have children, that we want to make sure is included in the will is guardianship provisions. So we would include this, that if the testator, who's the person making the will, does have children under the age of 18 years old, who they want to basically put in as the responsible caregiver if the parents were to pass away. So the executor will still be able to provide money to those guardians to care for the children, even though the children might not receive their entitlement to the inheritance they're receiving as beneficiary. They will still be, clothed, educated, looked after by the guardian until they reach that certain age. Again, with the guardian, we want to put someone in place that the client knows and trusts to look after their children. Sometimes clients will say to us, they want to appoint their brother and the sister-in-law. We often do say, though, we don't recommend putting the in-law in there, because if there is a breakdown in that relationship, we don't obviously want the children going to two separate homes, because we've listed both those parties on the will. They would have to essentially end up something like a shared custody agreement, which is not what we want. So we generally would just recommend that we just list the actual blood relation as opposed to the in-law. We'd still want a second layer though, so it may be they've got a sister, but then they've got, I don't know, another brother or something like that that they want to put down in the event that the parents both pass away. Now, sometimes obviously we have clients that come to us and they're not with the father or mother of the child. We want to let them know, obviously, that both their will and the parent of the children's will reflect the same guardianship provisions, because if they're going ahead and appointing someone who they want to be as the guardian and the other parent has put someone completely different in their will, there's obviously going to be conflict there, and it's not going to accurately reflect both parents' wishes, and there's going to be, contestant made of the will. So we do need to make sure that they both the same provisions in both those wills as to who they're actually appointing, to avoid any conflict down the track. When and why you should actually have a will drafted. So obviously you're wanting to do so, as I mentioned, to plan for the future, making sure that your hard-earned money and wealth is going to who you want to be the desired beneficiary of your estate. You don't necessarily have to have it go to a particular person. Sometimes, as I mentioned, we have clients that have got no family or friends that they want to leave their estate to, and so often people will nominate that the proceeds of their estate go to a charity. So you're by all means welcome to leave your entire estate or a portion of it to a charity of your choice. We would again just include them as the beneficiary in your will. Having a will in place will obviously assist to minimise and reduce the stress for your family and friends, because it's clearly outlined what your intent and wishes were, as opposed to family and friends having to potentially get into conflict and scrutinise each other. It's clearly written down what it was that you wanted to happen with your will. It can also help to reduce the cost to administer your estate. If you do pass away without a will, it's quite a different process in terms of applying to the courts for administration of letter to get the courts to appoint someone essentially to look after the estate, and then work out as to who it would have been that would have been the beneficiaries, which obviously can lead to greater dispute as opposed to when it's actually documented. So it is important to make sure that if obviously don't have a will in place, or the will's outdated or invalid for whatever means, that we do get one put in place to avoid situations like that occurring. What are the issues when you don't have a will in place at all? So that's when the laws of intestacy will actually come into play. Again, this is governed by our Queensland Succession Act. The estate may not be distributed then in accordance with what the testator, the person passing, would have wanted to have happen to their estate. If they don't have any relatives, their assets can essentially just end up with the public trustee, which is the state government, as opposed to, like I said, they might have wanted it to go to a certain charity. If conflicts do arise between the beneficiaries of the estate, obviously it can eat away at the proceeds of the testator's estate to deal with that. And the more money and time it will take to obviously administer the estate in the grand scheme of things. So when should you actually have your will updated? So obviously it's fine to have a will done, but you can't be setting and forgetting it. Things change in people's lives, and we do need to make sure we're looking at it and making sure that it accurately affects what we want. So we would recommend that you review your will every 5 years to ensure it's still current. Like I said, we'll have second layers for all the roles that we appoint in the will, but we want to make sure that, you know, if one of those people do pass away, that we get it updated. So we do always have that second layer. You know, sometimes there's breakdowns in relationships. You might no longer want someone you've listed in the will to be in there anymore. If you do get married or divorce, essentially the will be considered null and void, and therefore you will have no will in place. So we need to make sure that we get a new one done at that point. The same is for de facto relationships. If you have a child, obviously we want to think about adding then guardianship provisions and talking about maybe having them as a beneficiary in the vesting age, etc. And as I mentioned before, we want to make sure that we're updating it if anyone in the will does pass away, to have them removed and potentially replaced with someone else. Where should you actually keep your wills? Obviously, it's a very important document. We don't just want to, you know, have it lying around somewhere where we can, you know, get coffee spilt on it or it goes missing and no one knows where it is. So we want to keep it in a very safe place. When we draft a will for clients, we always offer the service to keep it in safe custody at no additional charge. But we always say that we want to make sure that your executor knows where that is. So if we're drafting it, we always say a lot of the times people don't like to let their executor or the beneficiaries know, you know, the total contents of the will, but at least provide them with the front page, which has got our contact information. So when the time comes and the executor needs a copy of the original will, they can come to us and know that we've got it held in safe custody, and help them with the assistance of providing the application for probate. When we do have clients from time to time, they may choose not to use that service of our safe custody and keep it in their own home, and that's quite okay. But we always say, you know, we want to make sure that it's properly kept in, you know, plastic sleeves, it can't get ruined, properly bound, and also, again, letting the executor know exactly where in the house that is located. People's houses can get, you know, full of lots of different paperwork, so they need to know exactly where to locate it when the time comes. The other thing I'll mention with the wills as well before we move on to power of attorneys is your will be based on the most current will that you have. So if we're to draft a new will for a client, any previous wills will be considered null and void. So the new will that we draft will basically include that it cancels out those previous wills that may be out there. So the newest will is always the most recent one and the one that will be used. Now we'll talk about what actually is a power of attorney. So obviously your will is dealing with everything once you're to pass away, whereas your power of attorney, we want to put that in place if you are to, generally the most common one when it will come into play is if you were to lose mental capacity. So if, for example, you're in an accident where you've in a vegetative state and no longer able to make decisions for yourself, or you could have a mental impairment where, you know, you may have Alzheimer's or dementia and you don't have the mental capacity to be making those decisions for yourself. So with your power of attorney, there's a couple of different ways you can do your attorney. So it's appointing someone for both financial decisions but also personal decisions. So personal decisions to do with health and financial, obviously, to do with your money and payment of bills, etc. The power of attorney can actually make decisions on your behalf in relation to both those financial and health decisions, but they must be doing so honestly to protect your interest as the principal and not the interest of themselves. Now, what are the actual duties then of the attorney? So they cannot disclose your confidential information to anyone. They must keep accurate records for all dealings made on behalf of you as the principal. They have an obligation to keep your property and your assets separate from their own, and they have to avoid acting as the attorney in situations where there would be a conflict of interest between their own personal interest and yours as the principal. So with your attorney, in terms of appointing them as well, sometimes we'll have clients come to us and say, you know, they really want their spouse maybe to act for them as the financial attorney, but they don't really, they're going to be too distraught. They don't really want them acting for their health decisions. So, they could appoint someone separately to act for health and someone separately to act for their personal decisions. We can do that as well. And again, with your attorneys, we can have multiple people appointed. So it could be that we appoint 2 people jointly to be acting for health and finance, or again, different, like separate for each, and the way that we appoint them as well. So if your enduring power of attorney document has not been prepared by you, then nobody can actually be appointed as your attorney. So it's obviously important that we actually have the document prepared, signed by both you as the principal and also the attorneys that you're appointing. Instead, an appointment of an administrator and guardian would be required if you did not have an enduring power of attorney document drafted. So the administrator and guardian, again, is a state government service that's offered, and the administrator is your financial decision maker, and the guardian would be taking care of your personal decisions. So obviously we want to avoid having someone that we don't know and trust to be that role. If you do intend to have a loved one or a family, close friend acting for you in your health and financial decisions, and we do need to make sure that we've got the power of attorney document drafted, signed, witnessed, and stored in a safe place for when needed. The other important thing, I think, as well for business owners, especially, is when they're a sole trader. Obviously the business needs to be taken care of as well in terms of paying potentially employees, suppliers, creditors, whatever it may be. That attorney will still act to allow whoever's appointed as that financial attorney to be making decisions for the business owner, and making sure things are paid, bills are paid, transactions are dealt with, so that the business can continue to carry on while the director does not have that capacity to do so. So in terms of appointing an administrator or guardian, so if, as I mentioned, you don't have the power of attorney in place, you would need to apply to have an administrator or guardian appointed through QCAT. So to appoint the administrator and guardian, there's basically 2 options. So it can be a loved one, like a family member or close friend that can apply. And if no one is willing or eligible to apply, then it would fall on the public guardian and the public trustee, which, as I mentioned, are the state government departments who would be appointed as the respective roles to act in your situation. Now we've dealt with, obviously, what is a will, what is a power of attorney, how they operate when they're needed. Now we're going to look at who can actually challenge your will in Queensland. So, it's fine to have a will drafted. It clearly sets out what the intent of the testator is and how it will operate. But we need to make sure then that we're also aware, we're also advising clients about when a will could be contested and how that operates. So again, it's all governed by the Succession Act here in Queensland, and there's 3 classes of people that can essentially challenge your will. Those being your spouse, whether that be by marriage or de facto relationship, your child or children, and also any dependents that you have. So, there may be stepchildren that are brought into the relationship through marriage that, they're still dependent on you. So who actually is a spouse? So the Act defines this as either a husband or wife. As I mentioned, it can be a de facto partner, which means it's 2 people living together as a couple on a genuine domestic basis, but they're not married or related by family. So this is according to the Acts Interpretation Act. They have to be 2 people living together as a couple for a continuous period of at least 2 years from the date of the deceased death. It can be a civil partner, so whether that's a partnership registered under the Civil Partnership Act, or a dependent, former husband or wife. So potentially there's been a breakdown in relationship, but they're still depending on that person for income. So who is a dependent former husband or wife then? So again, the Act defines this as a divorced husband or wife of the deceased. The divorced husband or wife cannot have been remarried or entered into another civil partnership with another person before the deceased passed away. De facto relationship does not disqualify you as a dependent former husband or wife. And the last one is, at the time that the deceased passed away, the deceased was giving their former husband or wife some type of maintenance. So, for example, this could be a monetary payment of a weekly amount, or they could be paying off the mortgage, or they could be paying fees towards something, car repayments, whatever it may be. And then who is a child? So under the Act, this could be a biological child through normal eligible children. If biological parentage can be proven or acknowledged, then you are the biological parent. Otherwise, it could be a stepchild or an adopted child. Now, stepchildren are considered under the Act, and the stepchild relationship will cease when you divorce from that biological parent of the stepchild, you terminate the civil partnership with the biological parent of the stepchild, or there is an end in the de facto relationship with the biological parent of that stepchild. The stepchild relationship does not stop when the biological parent passes away, or when you were still in a relationship with them, or the biological parent dies and you remarry or enter into a new civil partnership or de facto relationship. So who's actually a dependent then? So under the Act, this can be anybody being wholly or substantially maintained or supported by the deceased, regardless of whether they are a blood relative, and they must be the deceased parent, the other parent of the deceased child, or a person under the age of 18 years old. So do you qualify then, or when can a person actually challenge the will? So they must give notice of their intention to make a family provision application to the executor or administrator within 6 months of the deceased's death. So when we're applying for probate and probate's been granted, this is why an estate will not be administered and distributed to the beneficiaries until 6 months after the passing of the deceased testator, because we need to make sure that there has been no family provision applications made and essentially the will is not being contested, because if we've distributed the estate before we've allowed for that time frame, there's going to be repercussions for the executor that's done so, and they're going to have to try and then claw back that money, so which is why we always wait that 6-month period. So to start the challenge of the will, they must submit a family provision application with the Supreme Court of Queensland within 9 months of the deceased's death. So what does the actual court consider for a family provision application to be made? So they'll have a look at what the value of the estate is. So what is the size and value of the estate? What is the validity of the applicant's claim? So, again, making sure that they're eligible in terms of making sure they were one of the 3 people that we've listed previously, in terms of a spouse or a dependent or a child, stepchild, and what the contributions the applicant made to the deceased or another beneficiary before the deceased actually passed. The courts will also consider what the applicant's circumstances are in terms of the age of the applicant, what their physical and mental health status is. And the court may then look to award a successful application under the Succession Act. They'll have a look at the court may in its discretion order that such provision as the court thinks fit. However, the court shall not make an order in respect of a dependent unless it is satisfied having regard to the extent to which the dependent was being maintained or supported by the deceased person, they need of the dependent for the continuance of that maintenance or support. And there can be conditions that will be attached by the court for the maintenance, or maintenance can be refused by the court for disentitling conduct. So there will be times where the court allows the application to go ahead, and they'll put certain provisions on it, such as how much the person that's applied for the claim should receive, and whether there's conditions on it. So, as we spoke about before, like in terms of vesting ages, maybe they'll say that they are entitled to the estate, but not until they've reached a certain vesting age. Now, what happens if you have a will in Queensland, but the assets are actually located interstate? So practically, this will only apply if you have immovable assets interstate. So for example, an actual house that might be in Western Australia or Victoria, whatever it may be. Your executor or minister will first apply to have probate or the letters of administration if they don't have a will in Queensland, and the Supreme Court's grant of probate will only apply to the assets that can be controlled in Queensland. So any bank accounts you have in here, any houses that you have in Queensland will all be dealt with here. So any of those assets that can't be controlled in Queensland, like the house, that executor will need to then apply to have a reseal of grant of probate. So essentially taking the Supreme Court Queensland grant of probate, for example, to WA, to have the Supreme Court reseal that application so that the house can be dealt with over there. Now, for example, you may have a house in Queensland with assets in Queensland, but also have another apartment or property in New South Wales. So in this situation, your executor would be applying for a grant of probate here in Queensland. This process will take anywhere from 3 to 4 months, depending on what the court's timeframes are. We'll have to make sure that we advertise correctly, get the executors to sign off on that grant of probate, and then get it actually sealed by the courts before they actually issue grant of probate. The probate will only apply, as we mentioned before, to assets in Queensland. So once probate's obtained here in Queensland, the executor will then get the application resealed in New South Wales. And this New South Wales resealed probate application will be recognised and upheld for the Queensland probate as valid as well. There are still some special circumstances when reseal is not required. So for example, in Queensland, we do not need to have a reseal if the only asset in Queensland is a house or apartment, and there is a land titles registry form that accepts the interstate probate. So each state, as I mentioned at the beginning, do have their own succession act, and they do have slightly different variations to how we operate in Queensland across each of the different states in Australia. So if you have interstate assets, then multiple succession acts will apply. The Queensland Succession Act and the Queensland Probate will only apply to your assets here in Queensland, not interstate. If you do have any assets, for example, a New South Wales property, then the reseal of probate will need to be applied for in that particular state. And that can also obviously be challenged down there as well. It's important to note that the New South Wales Succession Act actually does allow grandchildren to challenge your will. So a grandchild could apply to the New South Wales Supreme Court to challenge your will and receive a proportion of the proceeds from your New South Wales asset. That's obviously different, as we went through before for Queensland, in that your children here is where it essentially stops. So it's your spouses and your children. There's no grandchildren that can actually contest a will here in Queensland. Now that kind of brings me to the conclusion of my formalities and what I wanted to basically explain to you today in terms of understanding what is a will, when is a will needed, how powers of attorneys operate, what happens if we don't have a power of attorney put in place, and then who can actually challenge and contest our wills. So I know it's a lot to think about and obviously quite daunting talking about estate planning with people. A lot of clients will, put it off and think it's not important, we'll get to it. And then we often get clients coming to us that then becomes urgent when all of a sudden they're going overseas, they're about to go into surgery. They want to make sure that all their affairs are in order before they do so. It is important, obviously, to make sure that we are regularly reviewing those documents, that they're in place well before anything untoward could happen, because unfortunately no one's invincible. We just need to know that all our ducks are in a row and we can, sleep comfortably at night. So we will leave it here, but by all means, feel free to get in contact with us. I'm happy to offer an obligation-free consultation to discuss your needs and to hopefully more tailor an estate plan for you and your loved one.
Thank you for tuning in to another episode of Property Powered Talks. We hope you found today's insights valuable and engaging. If you enjoyed the show, don't forget to subscribe and leave us a review. For more information or to connect with our expert team at MB Property Law, then please visit our website at noborderslawgroup.com.au. We look forward to having you join us next time for more expert advice and actionable strategies to master the world of property law. Until then, stay informed and stay empowered.